Craving everyone's indulgence, just sorting through a little technical glitch I'm experiencing. Meeting is formally called to order. Member Sinclair, may I invite you to say a prayer?
Dear Lord, we thank you for allowing us to see another day, take us safely to this place, and for those who are appearing virtually. We pray for your divine wisdom as we proceed through this most important reform process, the reform of our premier document. There are many voices and opinions, but we pray for your guidance as we navigate the issues to arrive at what is best for Jamaica and its people. In your name we pray. Amen.
Thank you. Any apology for absence?
I have received none, Chair.
Very well. Let me use this opportunity to welcome back everyone to this sitting of the Joint Select Committee to consider and report on the bill shortly entitled the Constitution Amendment Republic Act 2024. I want to extend a special welcome to our visitors in the gallery, students and faculty of the Michael Teachers College, you said, Ms. Cohen?
Yes, Chair. Michael University, if I'm not
Michael
mistaken.
University.
Right.
I hope that you will find the deliberations enriching. I've explained to other visitors that you will see a lot of empty chairs in the House because it is not a full sitting of the Parliament, but a committee, and the meeting modality is hybrid. And so some members of the committee are participating from the virtual space. This is something that has almost been normalized now in the post-COVID-19 pandemic era. Attendance in the virtual space also has its protocols. It doesn't mean that because someone is not physically present, all of the rules of the meeting do not apply. They very much apply. And in fact, great care has to be taken when one is present virtually because other things may distract, and there is also the tendency to multitask, but focused attention is required on the matter at hand. If you have not yet read the bill, it is available on the Parliament's website. It is available on the Ministry of Legal and Constitutional Affairs website. It is also available on the Road to Republic website. I encourage you to read it and don't be discouraged if you do not immediately understand everything. It is a legal document. Although we are seeking to simplify the language, it is still a legal document, but meant for the everyday man. It is the highest law of the land. It sets out the institutional arrangements. of the country. The Constitution itself, which is a schedule to the Order in Council, the Jamaica Constitution Order in Council, is also available. We updated the cover of the document for this constitutional amendment project, and we have put it in the Jamaican colors. So do familiarize yourself with the Jamaica Constitution. The bill that is before the committee is seeking to do very specific things in a phased reform of the Constitution. We are putting the Constitution in what we describe as proper form, taking it out of the Imperial Order in Council and having it stand on its own to be published in Volume 1 of the Revised Laws of Jamaica. And they are doing a very significant amendment, as you would have heard, to change Jamaica's form of government from a monarchy, which has the hereditary British monarch as our head of state, to replacing it with a Jamaican president reflective of our Jamaican nationality and our Jamaican identity, and whose office can continue to be an arbiter in the nation. These are some of the very important reforms being pursued in this phase. The next phase, we will look at the other branch of government, the judicial branch, the Charter of Fundamental Rights and Freedom, and related matters. So I invite you to pay close attention and follow the issues, because the changes that are being made in the Parliament will have to be approved by the people. And that is to say, those people who vote for the members of the House of Representatives in general elections. So if you are not yet a registered voter, you can enumerate to participate in the process. And I invite you to enumerate and participate in the democratic process. We have a representative democracy, which means that you elect your representatives or the Parliament, where we pass laws for peace, order, and good government. And so this work is to further the goals of independent Jamaica. When you attend in the gallery, the rules prohibit participation, clapping, and cheering. So we invite you to pay attention, and I will ask Member Charles, who is physically in the House, if you are still present when the committee breaks, that you'll get an opportunity to interact with him, as well as members of the technical team, primarily those from the Ministry of Legal and Constitutional Affairs. And this is the ministry that has carriage for the bill. Right, those would be my opening remarks at this time. The next item on the agenda is the confirmation of the minutes of the meeting held on February 26th. That was week before last, since last Wednesday was Ash Wednesday. So the minutes are before us. I hope members had an opportunity to read. We can begin at page 1, which has formalities by way of attendance. If there is no correction to page 1, we can confirm and go to page 2. And there is no correction to page 2. We can confirm and go to page 3. Ms. Cohen, I note that you use the term amended for precision. It's really for accuracy. Everyone should appreciate that the subject matter is quite nuanced, and so we strive to be as accurate as possible in ensuring that what is meant is captured. If there is no correction to page 3, we go to page 4. If there is no correction to page 4, we can confirm and go to page 5. If there is no correction to page 5, we can confirm and go to page 6. On page 6, the paragraph which commences, the chairman noted that the appointment procedure, and the last sentence, the leader of the opposition was given a power to recommend a nominee for consideration, but confirmation would be done by the Prime Minister. Please delete confirmation and replace with nomination. So the sentence, the clause should read, but the nomination would be done by the Prime Minister, not the confirmation. And I would just ask for just a revision of the very complex subjunctive tense. In the other paragraph, the chairman went on to say that the Ministry of Legal and Constitutional Affairs presentation comparing the parliamentary cabinet system and the executive presidential system had been intended to say was done to help the people to understand the essence of the parliamentary cabinet system. So I would ask that had been intended be deleted and replaced with was done. Any other correction to page 6? If none, then we can confirm as corrected and move to page 7. If there is no correction to page 7, we can confirm and go to page 8. If there is no correction to page 8, we can confirm and go to page 9. If there is no correction to page 9, we can confirm and go to page 10. If there is no correction to page 10, we go to page 11. Just for accuracy, I would ask that similar be deleted from that first sentence. The chairman stated that the proposed subsection 2612 had been influenced by experience where its other panels had been crippled, or just to change similar to other. The example I've cited would not be regarded as a similar panel, but a panel performing functions. If there is no other correction to page 11, and confirm as corrected, go to page 12. All right, if there is no correction to page 12, we can go to page, confirm and go to page 13.
Madam Chair, I do have a correction. In the final paragraph, the second to last sentence, the response there that's attributed to the chairman was actually my response.
I see, yes. So Ms. Grant responded that in the latter case, the provision allowed a wider selection of persons to be considered with a view to filling the vacancy permanently. Very well. Please delete chairman and substitute with Ms. Grant or the Chief Parliamentary Counsel. I think I may have reiterated it, but that's fine. So it would be your response and my agreement. Okay. So the sentence, the chairman responded, should be amended to read. The Chief Parliamentary Counsel, Ms. Grant, responded. And then where it says Ms. Grant agreed, it would be the chairman agreed. And then Ms. Grant added that the person who was selected for this temporary position could ultimately become the agreed president. Indeed, that was what, yes. And I think you're explaining that is why it was not limited in the same way that the other provision was limited. All right, so as corrected, we go to page 13. If there is no correction to page 13, you can confirm. Go to page 14. There is no correction. Will someone move for the confirmation of the minutes as corrected?
Dwayne Smith.
Thank you, Member Smith. Seconded.
Tamika Davis.
Thank you. All right, matters arising from the minutes. From my part as chair, I had mentioned, I'd invited members to consider whether an interim report should be prepared for the Parliament. I would ask that that matter consideration be further deferred. I, however, would like to just bring to members' attention page 8 of the minutes, just pointing out that questions and comments continue to be made about the proposed process for appointing the president. And although we are not yet at the point of considering the submissions from members of the public, I think it's important to reiterate what informed the provisions of the bill. Our research shows that great care has to be taken in what signals we send about the nature of offices. And in a parliamentary cabinet system, the day-to-day running of government is vested in the political directorate supported by a cadre of public servants and a subset of civil servants. And the parliamentary cabinet system has important differences from the executive presidential system. And we are not proposing a transition to an executive president. And I believe that some of the recommendations and concerns raised in the public are matters that seem to be in the crosshair of an executive presidential model, as opposed to a non-executive president in the parliamentary cabinet system. As indicated in the minutes, that in the deliberations of the committee, after considering the matter, that is the Constitutional Reform Committee, the decision was taken to design a process for meaningful consultation which should yield consensus, but that it was not the intention to provide a veto in the appointment process for the president, but to have the formalities done in a way that would yield a candidate that would gain wide support. But the process is not designed to be, to either yield an office holder that would be akin to an executive president, or to send any mixed signal about the nature of the office, nor is the process designed to provide any veto, but to allow for smooth appointment after meaningful consultation. I know some persons are reacting to this, and I've heard among the comments a thinking that it is giving a government its own way. I think a comment like that reflects not a sound understanding of the form of government that we are retaining and which we hope to strengthen. All right. Is there any other matter arising from the minutes that any member would wish to?
Good morning, Madam Chair.
Morning, Senator.
All right.
I'm going to just, hold a minute, please. I'm going to just go off camera because I'm getting a signal just to, until my internet is stable. So just a minute. I'm just going to go off camera to have.
All right.
Yes, listening.
I wasn't at the last sitting on February 26th, but going through the minutes and looking at the discussions that would have taken place, we were taking through the proposed amendment regarding the appointment of the president, and I just had a few queries, if I could be given the opportunity to raise them. And
sure.
so
please go ahead.
In the proposed 24(2)(b), where it speaks to the person who can be appointed as president has to be ordinarily resident in Jamaica for a period of at least 10 of the 15 years immediately preceding the date of the person's nomination. And I just wondered the use of the term ordinarily resident versus being resident and being resident for at least 10 years immediately preceding the date of nomination. Why was ordinarily resident?
Right. It's a term of art. May I invite either the CPC or Ms. Grant? Yeah.
I know what ordinarily resident means as an attorney. I do know
yes, that. Yes, Senator Sinclair.
But I'm just wondering
why
I ordinarily resident as against resident. And you said at least 10 of the 15 years. Why not just say the 10 years immediately prior to nomination?
So you raise a very important point about the ordinarily resident. The 10 of the 15 years as opposed to 10 years is to take into account temporary departure from the island or not long absence at all. So the residency requirement is because the criteria allow for Jamaicans by descent and taking into account the nature of our Jamaican population, where Jamaicans go abroad for whatever reason. We were not excluding our Jamaicans who may have not lived exclusively in Jamaica, but it was to ensure that a person who is being nominated to the office of president would have been present in Jamaica to be sufficiently aware firsthand of the issues in Jamaica and have a lived experience in Jamaica. And so that period was taken into account. The 10 of 15 is to allow for some flexibility. Now that you have raised the issue of ordinarily resident, I am immediately considering it from another aspect. But may I invite you to just say to the listening public what it is that came to your thought with the difference between being resident and ordinarily resident.
An ordinarily resident, you live in the island for 6 months, you're considered ordinarily resident here. So, I mean, over 15 years, I'm just trying to figure out, you're calculating that period, and I could foresee a situation, somebody ordinarily resident for 10, and then for the 5 years immediate to their nomination, they are not here, and then they are nominated. So I was just wondering why wasn't it say for 10 years immediately prior to the nomination that the person would have to be resident in Jamaica?
I'm just looking back on the notes of the deliberation, because at what point we had considered permanently resident in Jamaica. And I think that really was the intent. The 10 of the 15 years would allow the flexibility for temporary absence from the island, but the intention is to have someone who is actually present in Jamaica and resident in Jamaica within the period preceding the nomination to be sufficiently familiar and have a lived experience in Jamaica. I don't know what thoughts other members of the committee may have on the matter. A very good observation, Senator Sinclair.
And so, whilst we think about it, and I'm certain it will arise again at some other point, my next quick query related to 2610.
Just a minute.
where it says, for the purpose of subsection 8, the investigatory panel shall consist of 3 members, being persons who hold or have held or qualified, etc. So it's really the number of persons on the panel. No, it says 3. Why 3 and not say 5? And I raise that in light of another provision which says that the death or incapacity, okay, 12, that's 26:12. The proceedings of the investigatory panel shall not be invalidated by any defect in its composition due to the incapacity of any of its members by reason of infirmity, death, or any other cause. The panel seems a bit, with 3, seems small, and then you get to a situation where two knock on wood, die, or become incapacitated by some other reason, then one person can then send back a report, can do the investigation. That seems a little off to me for something as critical and important as doing an investigation into one of the top positions in our constitutional affairs. So I was thinking that 3, a panel of 3 is a bit small. And if we could look at it being at least 5. If you actually wish to state a number, or a minimum of 5, I don't know if there may be need. In fact, in our Court of Appeal just recently, we normally see the Court of Appeal sitting with 3, but for an important matter that came before them, that they had to give consideration to, they had a full sitting of the Court of Appeal with 9 members. So if from a drafting perspective, if the panel, the provision relating to the numbers on the panel would say a minimum of, or at least having 5 persons if we're going to stick to an actual figure, but a minimum of 5 persons, just in the event that something were to happen to any of them, that we would have sufficient persons still being there, that any report or investigation that goes through, we could be satisfied with that. It is not just a decision of one person. That's why I interpret what you have in the bill here, and so that's what came to my mind. So I raised it, not having been there on the last occasion.
Thank you, Senator Sinclair.
And in respect to 2611A about the interim report. An interim report being submitted when you're just merely seeking an extension, I think can create a challenging situation. It poses concerns to me in relation to an interim report being submitted. How detailed is that report going to be if the investigation is not complete? And you submit an interim report which may not contain necessarily conclusions that one would not veer from, but you have situations that may change as the investigation is continuous because you're asking for an extension in time. And all that is being applied for is an extension of time to conclude an investigation. I am concerned as to what could possibly be in an interim report that may when the final report comes out, maybe different, but then we put into the public space something that creates hurt, unnecessary hurt to someone, having regard to the nature of the investigations that are being conducted.
It's amazing how we can come to issues from different perspectives. So for all of us, for those of us who have had some judicial experience, an interim report can take any of many forms. The intention really is to indicate the progress made so far in the investigation and to indicate why further time is required to complete the work. We're not a jurisdiction that is very time conscious. Generally, we want to do what we want to do when we do it, and it just gets done when it gets done. So the thinking was that on a matter as important as this, without compromising the quality of the investigation, given the consequences that would flow, a time period is set within which the work is to be done, but recognize that it may require more time. So the requirement for an interim report on a request for extension of time is really to advise on the progress made so far and why further time is required to get the work done. The fact that the panel is to be constituted from persons who are qualified in a certain way means that the panelists would have an appreciation of these matters from a legal perspective. But I take the point that it may require greater specificity so that it is not left up to the idiosyncrasy is the word that comes to mind. It may not be the best word of a panelist, because we have been having experience in the jurisdiction that some of the things that we take for granted do not hold in certain circumstances. So, for example, the kind of judicious, temperate considerations that should attend upon persons who hold or have held high judicial office is not always demonstrated in heated moments. And the test of systems and the test of personalities is not when everything is going smoothly. It's precisely when you will have provocations that you want to ensure that training and experience are shown and that you have intemperate, judicious considerations and display in certain circumstances. And I can see how a process can become heaty and politically heated, and we may have departure from what was intended. So the question that comes to my mind, you having raised the matter, is whether we should specify a little bit more on what that interim report should look like. Because certainly it's not a final report, and you wouldn't want, indeed, prejudicial matters to be prematurely disclosed. But also bear in mind that the way the process is designed is that there are specified grounds that would have to be made out. So if you look back on the process of what would trigger the question, so the ground on which a president may be removed from office, the grounds are that the president is unable to perform the functions of the office, whether arising from infirmity of mind, body, or from any other cause. And that's kind of a standard way of making a provision like this. B, has behaved or is behaving in a manner that endangers the security of Jamaica. C, has behaved or is behaving in a manner that brings the office of president into disrepute, or D, is by that president's own act under a duty of allegiance, obedience, or adherence to a foreign power or state. No, what flows from that is that the question of whether the president should be removed on any of the specified ground may be put to the parliament. It says only upon the motion of the member of the House of Representatives who is responsible for leading the business of the government under the standing orders of that House, tabled at a joint sitting of both Houses, and setting out the grounds relied on, the proposed members of the investigatory panel, the time within which the investigatory panel should submit the report, which shall not in any event exceed 6 months from the date on which the investigatory panel is constituted. And the motion has to be carried on a 2/3 majority of all members of the House. So inbuilt in the process is something by virtue of what the vote that would be required to carry the motion, that the grounds that are set out, there would have to be some prima facie evidence, for want of a better word, to show that a threshold is met. So this is not a matter that is going to be embarked upon lightly. So already you would have something damaging, at least an allegation, that would be injurious to the person continuing to hold the office of president. I don't know if when you consider that ex ante position and what you are saying about the concerns about an interim report coming later on, if that helps to answer the concern.
Well, I've heard your comments, and I see what it sets out the grounds, but then when we get into when we talk in Jamaica and say the nitty-gritty of it,
yes,
you might find some things that are, yes.
So you are saying that perhaps
about
yes,
how, when you're seeking an extension of time, how wide should this interim report actually be? To say that we're seeking a little more time beyond the 6 months because we need to set out the reasons why. We need to call 2 more witnesses. The time did not facilitate us in the 6 months that was given, or as the case may be. 2 more witnesses are needed in order for us to complete our examination, obtain the evidence, etc., etc. And that's it.
So really some qualifying words to justify the request, for extension instead of leaving it wide.
Yeah, yes.
Got you.
And,
Got you.
Yeah.
Got you.
And my last query, Madam Chair, which would touch upon 26, 13.
13?
26, yeah, 13 on page, I have it on page 16 of the draft bill that I have there.
Yes.
All right. The report now comes. The report is submitted to the Parliament. Parliament shall vote by secret ballot at a joint sitting of the Houses on the question of whether or not to remove the President from office. And if each House, by a 2/3 majority of all its members, votes that the President should be removed from office, the office of the President is vacated. No. The report that is coming with recommendations.
Mm-hmm.
to say, basically saying that the allegation has been satisfied. So they are the only body that would have got the evidence, summoned witnesses, and heard witnesses. And they know, having done all of that, and when we look on the persons who form the panel, you're speaking of eminent persons, persons who are judge of court of unlimited jurisdiction in civil and criminal matters, or from the jurisdiction of those courts.
It's a quasi-judicial body.
Yes, but we're speaking about a body of persons who are learned and trained and know how to dissect and so forth, more than probably persons who are elected in Parliament. And now they send and say, well, this is what our findings are. We have found that one of the grounds for removal of the president exists. And then 2/3 of the Parliament says, well, although you find that, no, we're not going to give a 2/3 vote. So the president remains. Just asking if that is what the outcome would be. So this eminent body, who hears from everybody, including the president, makes a recommendation. But the Parliament said, no, man, we're not giving you 2/3 for whatever reason. The president remains. But then we have a report that is out there in the public that indicates certain things. The grounds have been established, or whatever else comes out in the report that may be unfitting of a person holding the president. But the Parliament decides, well, we're not giving you 2/3 for whatever reason. And for whatever reason. Yeah. You hear it right there. The Parliament just decides where the president remains. I'm not giving you 2/3 majority. Is that what this is saying? Just asking for some clarification.
Tell me what just amplify the point that you're making further for me.
I don't know how I can amplify it any further than I have.
So when you began, I was wondering whether you were saying that the Parliament itself should have an investigatory powers and resources instead of relying on the quasi-judicial body.
But the Parliament,
but as you proceeded,
Parliament is not relying on them. The Parliament is not relying on it. It's not a situation. All right. Let us look at a situation.
No, the Parliament is going to rely on the information that is presented to it.
And the
that happens from time to time. For example, when policy white papers are put for debate, or even a bill that not everyone in the Parliament may have participated in making, because the power to pilot the bill, or in our system, the government is arranged in ministries, departments, and agencies. And so policies are formulated in ministries with the portfolio subject matter. They are then approved by the cabinet. Matters are voted on in the Parliament. And the decision is done in reliance on the information presented. You get an opportunity to interrogate the information in the same way that we are interrogating the bill, in the same way that a debate on the report would take place. But if you are debating and you're investing in a body which is qualified to consider whether legal thresholds have been met, due process has been met, knowing the consequences that would flow if all that, the formality and a recommendation is that, having investigated the matter, the ground set out, has been made out, or another ground provided for in the Constitution has been made out, the expectation is that the lawmakers would do the right thing, because unless you are saying that you do not believe the report, you do not accept it, it is perverse, etc., etc., because built in the process is that the president has to be heard from also. All right? So if you look at 9, it says before submitting the report to the Parliament, the investigatory panel shall give a copy of the report to the president and afford the president the opportunity to respond thereto within such time as shall be specified. So we're building into the process what we believe to be appropriate natural justice steps. And even if they were not directly specified by virtue of the law, common law, it would still, the subject matter of the investigation would still be entitled to the due process. But we already have examples where that is not always honored, so we have built it into the process. So is it too much to expect going forward that lawmakers will understand and appreciate what they themselves have legislated and honor that?
Well, let me ask you, Madam Chair. Suppose the report having been done by the investigators, first the panel, and they submit it to the president, and the president's response says, I don't accept, etc., etc. When we leave from, for example, joint select committees, you may end up with something that we refer to as a minority report. So the panel says this is our findings, but the president's position, which is now reported on, says, what you have there, I don't accept it, nothing like that. All of that is false and created by whatever reason. So you have two positions by the process of natural justice that comes before the parliament, and it is now for the parliament to determine by a 2/3 majority what happens. That's what you're saying. We have a situation under the Parish Courts Act where you have disputes that arise in respect to boundaries, for example. And the matter can be referred to a commission surveyor. The commission surveyor goes and does his inquiries and etc., measurements, draws his maps, and then does a report and presents that to the court. You know, that can be the end result, that ends the matter. Whatever they're finding, the finding of that commission land surveyor reports brings the matter to an end, because his report is what the parties agreed would have been relied on. In this case, you have no, the parliament, by its motion, divested itself of the investigation to a panel to go and do all the inquiries that needs to be done, applying all principles of natural justice. You give them the authority to establish your own procedure, call for direct and evidence and witnesses and so forth. And having done all of that, this eminent panel now makes a submission to Parliament with a finding to say we have found one of these grounds is clearly established, and here is the report, and the Parliament is to vote to determine by a 2/3 majority whether the president stays or goes. That's what this is saying. And I'm just saying, if that report comes and you don't get the 2/3 majority, then the president remains. Is that what I'm to understand?
Well,
Madam,
what
Madam,
you are to
is
understand,
that
yes,
correct?
is that
The
in
president
order for the
remains.
president to be removed from office, the parliament that makes the confirmation of the president's appointment, is being empowered to make the decision based on material presented to it or the removal of the office. But this matter raises another question to my mind, and this is why interrogation is so helpful. And, just subjecting the bill to review is really quite helpful, because one of the issues that arose is on what vote should the confirmation take place. All right. And after working through the challenges presented, the CRC recommended that we would instead propose a mechanism for meaningful consultation that, with reasonable actors, should yield a candidate by consensus. But we know that sometimes reason escapes. I'm just making a link in my own mind between the process of appointment and the process of removal. The vote of an absolute majority at the start, the vote of a 2/3 majority at the end, and to see how, and if at all, that may be problematic.
Yes.
Because while at the start you want to facilitate a process, you also do not want any part of the process to be based entirely on partisan consideration. And so matters as important as removing a president from office is a matter that we say should be elevated above narrow partisan interests, and that objective criteria be established and made out, and that the establishment of the criteria would be put in the hands of a quasi-judicial body, but that the parliament would come back and play its role. But Senate Member Sinclair, your questions raise some of the very difficult issues that we grapple with when we consider the entire matter of impeachment, because this really is an impeachment process of a president. And if you look back on the report of the committee that was tabled as a ministry paper, we would have set out in that some of the concerns that were at the forefront of our deliberations in the matter. I don't think that we can eliminate concerns about partisanship in politics. Partisanship will be present, but is unhealthy partisanship or bad actors, perverse actors that you really want to guard against. I hear from you, and I stand corrected if what I am perceiving is not what you intend, that at the end of the day, you may end up with a president, you may end up with a vote which does not meet the threshold to remove a president from office, that an investigatory panel has said the ground for removal is made out. And for whatever reason, the vote threshold is not met. And the question is, are we left with such a president in office? And what damage would result to the office of president if such a person were to remain in office after a quasi-judicial body has sent in a report to say, having investigated a complaint of misbehavior in office or inability to perform the functions of office, or conflicted allegiance, the person has run afoul of the law. I see the danger. So the question is whether something more needs to be provided for, and who would have that power, where the panel has made a recommendation that the ground set out or another ground specified has been relied on, but that the vote for removal does not meet the threshold. What should happen? That is what I understand your ultimate concern to raise.
That is correct, madam.
Yes. May I invite other members to weigh in? And any comments from the technical team? So one consideration that is coming to mind is whether the initial vote should be a vote of 2/3 or whether this vote should be a vote of an absolute majority. And then the same question that arises at the confirmation stage that would arise and perhaps could be answered is how do you guard against unhealthy partisanship? In the first analysis, we say that if a process is designed for meaningful consultation, but at the end of the day, it does not yield a consensus candidate, we still have to find a way to make the system work in a worst case scenario. And since we are not putting in place an executive president, then we can justify the formalities of having an absolute majority with a deference being given to an elected government who would have gone through a democratic process in a representative democracy. So what I hear you probably saying, Senator, is that maybe a different vote should be considered. The committee thought that a matter of the removal of the president would be a matter where parliamentarians would step back. That's why we have established specified grounds. That's why we have put, initially the matter was being investigated in the parliament, and the submission, the change that we made, which found its way in the bill, was actually based on concerns raised by the leader of the opposition, who is a member of the committee but is not participating in the deliberations of the committee. But I'd be curious to hear what your proposal is, because I see the dilemma that you have raised. A matter of policy, yes?
I have not actually
You're not allowed to be devil's advocate without a solution.
Pardon me? No, I'm just, I have to raise it. I first of all have to raise it in my own mind. And I've been gone through it, as I said, and I was reading through the minutes and the actual document last night. I have not come to a final position, but I can just see a situation where, if you don't get 2/3, then you have just a real difficult situation that exists. You spoke about absolute majority, and remember you have the buffer. You know, why I'm not too concerned or have much concerns about just an absolute majority in this situation is that you have a buffer which exists, which is a panel of persons that are, we can, without knowing who they are at this particular point in time, but there are persons who are going to be eminently qualified. And when we try to determine who will make up those numbers, Parliament debates that in its motion as to whether they accept the panel that is being proposed. So there is a buffer that exists, and so we expect that there will be persons who are, as I said, qualified, objective, and can go through the entire process. They would have the opportunity to do all the inquiries and so forth that they need to, and then they come back with they would come back obviously in their report with facts, what they have discerned from the witnesses. They would have come back with their recommendations, and obviously if they need to, they would attach the evidence. So I am the 2/3 majority in respect to the removal. As I said, with that buffer in place, I don't see the need for it. And once you have an absolute majority, then can
what about though the 2/3 for the motion to carry? You think at that stage the 2/3 is an appropriate threshold for the motion?
For the motion, I don't, and that is in itself a buffer too.
Yes.
So
you're saying
yes.
saying that keep the motion at 2/3,
yes,
which would at least take it across parties across the aisles.
Yes.
And then if the panel comes back in with a recommendation that the grounds have been made out, which means that the president should be removed from office, then that is dealt with an absolute majority.
I don't have challenge with that personally. That's my personal position.
Well, we're not legislating for our personal convenience, but you have raised a very good point.
When I say personal, personal because I've not discussed it.
Your personal view,
other
I
members.
see, as a member,
Yes,
as a voting member.
Yeah.
Oh, got you. No, but the logic is clear. So when we were looking on Parliament's role in respect of the office of the president, we thought that we would do something that was both symbolic and substantial at the same time. Currently, we do not have any provision, constitutional provision, for both houses to sit together. We do it conventionally at the opening of the parliamentary year, at the opening of a parliament after general elections, or when we have visiting heads of government or heads of state, and they are addressing the parliament. So we have a well-established convention on when the two houses of parliament sit together. These amendments were going further to provide a constitutional provision mandating in a nice symbolic way, but also for substantive issues, and particularly on the transition from a monarchy to the Republican form of government, to have the two houses sitting symbolically to confirm the nomination of a duly qualified candidate. And then the thinking was that anything having to do with the office by way of removal, so if the appointment is confirmed, any removal would also be ultimately confirmed by the parliament, and aspects of the work would go out and placed in appropriate authority to deal with. Members of the ministry, any view on the matter?
Madam Chair, it's not directly on the matter, but something that arose tangentially to it. Just inviting consideration of whether there needs to be some provision also protecting the panel from any proceedings as a result of their findings and investigation.
Yes, and we have legislation which has some immunity. Yes. Yes, I think that we have seen things played out in the jurisdiction, Madam CPC, that it would be wise to make such a provision. All right, I don't know that we can answer this matter now, but I have, just a minute. I have been looking at the matrix so far with the submissions that have come in. Madam Committee Clerk,
Madam Chair, before we come off that, because in my comments, I actually made mention of persons who and may have been my misreading, persons who are judges of unlimited jurisdiction or the appeal court. But I am realizing it says, or are qualified to hold.
Yes.
So they don't have to be actual judges. They can be. And that probably may also raise a concern to me.
Well, put it this way, Member Sinclair. We do have a finite number of persons present at any time in the jurisdiction who have held offices in the judiciary. And we have a number of other pieces of legislation, though the Constitution is at the top, which draw on them. We expanded the provision to say we would not just limit it to those who have held, but those who are qualified to hold, to allow for greater flexibility from the pool. But the same principle applies, is that these are persons who would be sufficiently experienced to understand the legal issues that would arise in the matter. Not just legal, but legal and other issues that would arise, but certainly would be trained and experienced to have at the forefront of their minds any legal consideration that would be required.
You have broadened the pool because you said whether in Jamaica or elsewhere.
Well, normally we would say from a Commonwealth jurisdiction, and we have had it is the norm, not only here but in. I
don't have a problem with that, but what I'm saying is that you have a wide pool, even if you were to confine it to persons who have sat as a judge.
Yes.
In a court of unlimited jurisdiction or an appeal court, because you have widened it to say whether in Jamaica or elsewhere. So you're contemplating persons from anywhere at all across the world, not only in the Commonwealth. So you do have a wide pool. As again, so the need for or qualified to hold.
We struggled with a decision that we took about where do we place reference to the Commonwealth, and what you see or elsewhere as opposed to a Commonwealth jurisdiction was a reflection of that decision. But it's really jurisdictions that have similar legal system to ours. The other matter, we are not going to be able to answer these questions. We would have to go back to the ministry on the policy issue, and I certainly would be inviting the CRC to weigh in on the matter and provide a recommendation for consideration, if need be. So I'm going to ask the ministry team to note the questions, though the minutes would reflect them. Just note the questions for our further deliberation from a policy perspective on the matters. In respect of the size of the panel that you had raised, Member Sinclair, so we choose an odd number so we don't have deadlock, even though you can always provide for how a vote is to be taken in the event of an even split in votes. And bearing in mind that ultimately if a matter goes to court, for example, you can have a single judge. You can have a single judge adjudicating on it. The size of the panel is not necessarily the defining factor. I know that you made reference to the empaneling of a larger panel in the Court of Appeal. So a panel of the court is 3, but the court now has 3 divisions. And I think in the past, when it had 2 divisions, which would be 6 judges or 7, the extended panel would be 5. Now that they have 12 or 13, they go to 9. That's just a reflection, prorating of the overall size of the court now, and the circumstances in which an expanded panel sits is set out conventionally if they are revisiting an important matter or they are overturning a previous decision or a matter of high constitutional importance. Just to say, which I believe you already know, but for those who may not be familiar, who are tuned in and listening. The question of why ordinarily resident and not permanently resident is something that we will have to look at, because the intention is to ensure that the person is actually in Jamaica. Momentary, temporary absence would not disqualify you. And it is not the intention for the person to be here half a year and half a year out. You must be permanently resident in Jamaica. I think what we had grappled with is whether temporary departure from the island would impact the standing of being permanently resident. But many of us who are now permanently resident are temporarily absent from the island, and that temporary absence does not invalidate our status of being permanently resident. So we will look at those. But thank you, Member Charles. I am grinning from ear to ear, even if you do not see it on my face, because this is the kind of detailed consideration that I hoped for from members of this committee. So I'm really pleased that you have raised matters that are important and which bring fresh eyes to the provisions before the committee.
Madam Chair?
Yes, Member Golding.
I didn't want to interrupt Senator Sinclair's interrogation, but I do want to ask some questions myself in relation to the provisions that he was concerned about. And so let me just start from the point of the ministerial committee report that looked at the when it looked at the process for removal of the president. I know it was proposing a parliamentary committee at that time. The bill, however, has departed from that, and now we're talking about this panel constituted by persons qualified to be Supreme Court justices and Court of Appeal judges or having held the office. And I start first, my concern starts first with the with the question as to what exactly is this panel intending to do? What is the work, the role of this panel? And as far as I can see in the bill, the specific role of the panel is to investigate the question of whether the president should be removed from office. And the bill also proposes to establish in the Constitution the grounds on which the president may be removed from office. And those grounds are that the president is unable to perform the functions of the office, whether from illness or any other cause, that the president has behaved or is behaving in a manner that endangers national security, that the president has behaved or is behaving in a manner bringing the office into disrepute, or that by the president's own act, the president is under a duty of allegiance, obedience, or adherence to a foreign power or state. So those are the 4 grounds that the panel purportedly would be seeking to satisfy itself that one of these 4 grounds has arisen, is present, in order to make a determination after its investigation as to whether it would recommend the removal of the president. And the question I have in considering the function of the panel and the context in which the panel is to do its investigation is now related to the manner in which the panel is constituted. So in the previous iteration of the ministerial committee, the panel came from the parliament. And obviously that was abandoned at some point. The bill now proposes that a panel be established in the parliament or by the parliament. And my concern is, what is the mechanism for this panel to be named? Bearing in mind that the naming of these kinds of panels sometimes, well, quite oftentimes it is a portfolio minister who will come to Parliament, name appointees to a panel tribunal, and if it's not prescribed by law, and it's sort of declared in the Parliament. So my question is, 1, who is doing the actual naming of the panel? And if it is being done by the Parliament, is it being done by the Parliament? What is the process by which the Parliament approves it? Because a minister coming to Parliament to name a panel that is intended to investigate the question of removal of the president does not, in my view, require the participation of the opposition. They may object to the members named, but there's no real power there to opine on who becomes members of this panel. So that's my first concern. And I'm not landing on either side, that one is better than the other. I'm just having an inquisitive moment and saying, is this the appropriate methodology for the naming of the panel? That then led me to consider the question of, why is there the naming of a panel by the executive to remove what is essentially an executive office, when that office, the method of appointment of that office can only be done through the Parliament. And I wondered if there had been any consideration, since the work of the panel is essentially determining what is a breach of the Constitution under this proposed bill, because the bill proposes to place in the Constitution grounds for removal. It means, therefore, that if a sitting president commits acts that fall within any of these 4 grounds for removal, that the sitting president would have breached the Constitution. So if we are talking
Sorry,
about...
could you just repeat that?
I'm saying we're asking the panel to investigate a matter that is essentially a breach of the Constitution. The actions of a sitting president that would fall under any of the 4 grounds proposed in the bill would, if these grounds are enshrined in the Constitution, be a breach of the Constitution, his very actions. And so if we are asking for the panel to investigate a breach of the Constitution, my question is, why is that panel not the judicial body? Why is it not the Constitutional Court, or whatever the provisions are in the judicial branch, that is investigating and coming to a conclusion, as they do in their judgments, as to whether or not the sitting president has breached the Constitution? Constitutional matters are dealt with by the Constitutional Court. We are creating a separate system here that seeks to put in place a panel that, from my reading, is essentially established by an executive member. The president's office is an executive office. And so I'm questioning whether or not the scheme proposed here is the appropriate scheme, given that the matter that the panel would be interrogating is essentially a constitutional breach as it's being proposed. Those are my questions, and I yield for comment and response. Thank you.
Before I comment, any other member has anything to weigh in on that? Just to not have you or another member wait as long as you did when I was responding to Member Charles.
No, well, I didn't want to muddy the waters.
No, all right.
Because we can get entangled. So I thought it was appropriate to wait, and I'm glad I did, because I too was being edified by Senator Sinclair's questions.
So the panel, so first of all, when there's a task to be done, that task has to be assigned to someone in order for it to be done. So the current provision assigned the task of naming the members of the panel to the leader of government business. Conventionally, these matters involve consultation with the other side. Question is, do we spell it out? Do we take it for granted that it would be done that way? We have many examples of things taken for granted and not holding. So that's one set of consideration. The question of why the executive determining a matter that the parliament is dealing with. Remember, in the parliamentary cabinet system, the executive is a subset of the parliament. So the executive is drawn from the parliament. The other matter of why not have the Constitutional Court determine the matter in the first place. I think these are all questions that resurface the difficulty of providing for a system of impeachment in a parliamentary cabinet system form of government. So one of the early feedback I got to the bill from a man in the street, literally a man in the street, but which was also reiterated by someone else that I met, is why have only the leader of government business initiating the motion? Do you run the risk of a motion not coming for political partisan reason? And the when I deliberated with that person, literally on the street, I came away thinking that perhaps a better provision would be to allow for the motion to be tabled by any member of the House. And that way, you minimize, if not eliminate, any risk that inhere in a matter not, and motion not getting on the order paper for tabling for improper political reasons. I don't know that there is any easy answer to the question, but a system of impeachment really is about colleagues hearing and determining and disciplining, for want of a better word, other members. So the office of president is the non-political part of the executive branch. And then you have the political executive, which would be drawn from the parliament. I think it's as far as I can go right now, preliminarily, in answering your questions, Senator Golding. But the entire an impeachment scheme is really problematic in a parliamentary system. And I have to, at this time, acknowledge the guidance that and research that Dr. Barnett provided to the committee in helping us to better understand this matter, as people are calling for greater accountability for holders of high offices and especially institutional offices. We managed to quote an improved system. I guarantee you that the next question that we consider is why not have the system apply to all members of parliament, which is one of the big calls in the society for issues of accountability. I can only say at this early juncture that until and unless we get parliamentarians to do the proper work that is assigned to them constitutionally, we may have people raising issues about the performance of parliamentarians, which properly has nothing to do with the rightful role of the parliamentarian, and which task is assigned formally to another part of government. But, you know, the parliamentarian is the first point of interaction between members of the public and government. I say, for example, every time my constituents say to me, MP, you don't fix the road, or MP, you fix the roads, I say to them that as member of parliament, I work collaboratively with other persons in government, and I will make representation for a particular road to be fixed because I am in the constituency, I see it, or also I hear your concerns. And when I make the representation, I ensure that it gets on a list for proper consideration, meaning that it will be assessed. That assessment is not done by me, the MP, but depending on the category of road, it would be done by the NWA, the National Works Agency, or by them on behalf of the municipal corporation in respect of community roads, or by someone else in respect of farm roads. And that is not a job that the MP is either equipped or able to do, but you are the one being held responsible for the outcome. And so if you succeed in getting a road on the list, you succeed in getting the road assessed for the cost for fixing it, then you succeed in getting the budget allocated for it. And then you have nothing to do with the award of the contract. You may have a say in recommending a contractor, but you do not participate in the formalities around the award of the contract. And then when the contract is awarded, the contractor has certain obligations that he or she has to meet. And if there are delays, you are still being held accountable, when truly it has nothing to do with you as member of parliament, but in the minds of the public, you are the one whose neck should be on the block. So to my mind, while I support without hesitation the call for greater accountability in government, we have had a breakdown in government for the many years of disinvestment in government, particularly the matters that are directly related to the decades of economic decline, when there was just no investment in government. And everybody now sees the parliamentarian as responsible for the work of all of government. So this matter does not have any easy solution at all. Finding a neat way of dealing with an impeachment process. Again, going back to the recommendations of the Constitutional Reform Committee. If you look back on the section of the report, which deals with impeachment or consideration on impeachment, this just to remind members, if you do not have the report to hand, and if you do, to direct your attention to where in the report it is contained, and for members of the public who don't know, to inform you. At page 28 of the report, paragraph 6.3, impeachment process, the committee reported to the cabinet and the cabinet to parliament that during its engagements, the CRC took into consideration the repeated concerns expressed by the public about the lack of accountability among parliamentarians. The CRC discussed at length over multiple meetings the related issues. In particular, the CRC acknowledged calls for the inclusion of a process of impeachment and examined the history and experiences of impeachment in other jurisdictions. The CRC further considered whether and how impeachment would work in the Jamaican context. Then at paragraph 6.3.2, the CRC recommends that there should be no inclusion of an impeachment process in the reformed constitution for the following reasons. One, it is dealing with what is essentially a legal matter through a political process, as most impeachable offenses are criminal in nature and properly triable in the courts. Two, it can easily be manipulated for partisan political purposes. It is difficult to ensure an impartial hearing by members of a parliament that is divided along partisan political lines. Three, the parliament would have to be provided with its own investigative resources. Four, when the matter being investigated involves the allegation of a crime, then the normal criminal proceedings would be invoked, which creates the risk of competing and conflicting jurisdictions and outcomes. And five, in cases where impeachable offenses are not criminal offenses, the definitions are generally vague, and therefore the impeachment process is inconsistent with the principles of natural justice. And this really is just a summary of what we grappled with and what we thought we needed to, we meaning the Constitutional Reform Committee, and by extension, the ministry, we would report. And just from what is raised in your questions, Member Golding, and in the questions of Member Sinclair, we are seeing these difficulties emerging in the deliberations. And there are no easy answers, as I say, because there can be an alternative to anything proposed. But again, the executive...
Interrupt you for a moment, because you read the section just now from the CRC report.
Yes.
In relation to impeachment. And,
Yes.
and I have to tell you, it puts me into a little bit of confusion, because previously in the report at paragraph 4.10.3, the very same CRC recommends a process of removal of the president from office for the reasons that have now been proposed in this bill as grounds for removal. Well, what are grounds for removal? That's a process of impeachment. Impeachment is removal from office on the grounds of bad behavior. The grounds here are expanded in that removal can be because they're unable to perform their functions for illness, reasons of illness, and so on. But it is essentially impeachment. And so I'm wondering if we are not getting a little confused and maybe inappropriately utilizing a political process versus a judicial process. Because once the grounds enter the Constitution and are enshrined in the Constitution, then the interpretation as to whether or not that provision contained in the grounds have been breached properly belong with the courts. I don't understand, if we're going to insert these grounds, how we then create a system essentially adjacent to the body that does interpretation of law and say, well, this is the body appointed by the minister in the parliament and there's a parliamentary process. If that is the case, then those grounds ought not be in the Constitution at all. And maybe there's a way for the Constitution to opine on the possibility of impeachment. But it would seem to me that once you put the grounds in the Constitution, then the authority to determine whether that constitutional provision has been breached belongs with the court. And I'm grappling with that, because with what we have here seems to be a bit of a confused scheme.
So I began by drawing an analogy to the impeachment process to say substantially what this is an impeachment type process. The grounds for removal are not criminal grounds. We're really saying that if these things are made out, you would be ineligible, you would not be fit and proper to continue to hold the office of president. So that's an important distinction. And a constitution which creates an office can properly say, if you set the criteria for holding the office, you can also set criteria for not holding the office. So I, to my mind, do not see anything improper with that.
Then what is the justification for putting that in the Constitution? Or should then those grounds be part of the bill? Because I am not aware that we have any place in our jurisprudence, and I stand to be corrected, where a parliament interprets the Constitution. The parliament makes the law, and the parliament can revise, amend a constitution, but for the parliament to determine what is a breach of the Constitution, to me, seems to be highly inappropriate from a jurisprudential perspective.
I think I would frame it a little differently. And again, it does not lend itself to an easy answer. And I'm not going to be concluding on the matter in this exchange either, because these are matters that we grappled with. There were some who thought that the committee, the CRC, in its advisory role, that is, I throw back that because we went through a process to get to the bill here, even as we are reviewing it as a parliament. Members of the public may not have sufficiently understood the challenges that we grappled with over multiple meetings, having done extensive research, on the matter, having considered it at length. But like I say, the farthest I can go preliminarily at this point is to say that it is not that the questions you raise reflect challenges that we grappled with. As we summarized, we meaning the CRC report tabled as ministry paper, and raises some of the questions that you are now grappling with. But at this time, I would say that the Constitution is prescribing. So we are in new territory, you know, we're in new territory. And I keep telling members of the public that there is such a good logic to our doing this work in a phased way. We already know the overall goal, but we are in uncharted waters. And even while we may look to other jurisdictions who have traveled the road ahead of us, we still have to create something that is appropriate for Jamaica in its own context. Even if we're not reinventing the wheel, we have to adapt appropriately. But there are no easy answers to some of the questions. But we are replacing a hereditary monarch with a president. The monarch now has the personal representative, who is the Governor General. And that Governor General is appointed by the monarch. By convention, it is on the recommendation of the government. And the process that takes place is that there would be consultation between a prime minister and the leader of the opposition to settle the recommendation for the monarch's personal representative. And fortunately, in the jurisdiction, we have seen it happen across administrations without issue. Even when the nominee confirmed as Governor General has been drawn from the political class, as we have examples on both sides of the aisles. I think Sir Clifford Campbell and Sir Howard Cook were parliamentarians before. We have not had the office of our de facto head of state brought into disrepute. And by and large, even with insufficient understanding of what the office does, it has maintained a certain level of esteem and discharges state functions with dignity. But the point is that, so the Constitution is now creating an office of president for head of state. It is prescribing the criteria for holding the office, and it is also prescribing grounds on which you may be removed from the office if you are no longer. It's not creating a crime where you would be liable to a conviction and imprisonment, and your liberty would be engaged. If a crime is alleged in the ground, then that would have to be dealt with by the court. But constitutions do make provisions like these. What would be so unique about Jamaica? The question meaning that even in parliamentary cabinet system, you have grounds for removal. In the day-to-day course of life, people can be removed from any office that they hold if you go through a proper process. Or public service regulations. We mustn't confuse the difficulty in administering provisions. So we have to look at that and make changes to make it less difficult to say something is wrong.
I'm so sorry. I want to interrupt you. Please pardon me, because I don't want my concern to be lost in a discussion of the various mechanisms that one can put in place for the removal of offices. Because the truth is, I am not aware that there is any place where we have provisions, constitutional provisions for removal that are determined by the parliament. And that is my issue. When we talk about offices where there provision to remove a person from office, those are usually statutory provisions and or even regulations, something that comes in the scheme of a law. My concern is Parliament making law, writing a constitution, passing a constitution, whatever the process of that is, and then having to deal with provisions within that constitution which requires the parliament to interpret the law, because the panel that is conceived in the proposed bill reports to parliament its findings and its recommendations, but parliament is not bound to accept the report of that panel. So if this is essentially a political process, which it sounds to me that's the process we are designing, then why are these grounds in the Constitution? Because once we put them there and those grounds are satisfied, that's a determination that should only take place in the court. Only the court should be empowered to interpret the Constitution in a final way, so that, and here is the mischief that I am now going to suggest. If the parliament votes by 2/3 majority to remove the president on one of the grounds set out in clause, excuse me, 26 is the I'm so sorry. I lost my way.
Just to say though, Senator, while you look for that, there are other provisions in the Constitution where a holder can be removed from the office without it becoming a court matter. And unless you're therefore saying that that is all. So, for example, if you miss a number of sitting, the standing orders allow for a process.
Right.
So that's not a matter of interpreting the Constitution, it's activating a mechanism. So there are other provisions in the Constitution.
Let me just finish the point.
Where the holder of office is removed other than through a process of the court.
Okay.
Yes.
Okay. So the point I was making, if the parliament votes to remove the president, consequent on the recommendation of a panel, or even against the recommendation of the panel, because it is empowered so to do, can that president file an application in the courts? Can that president go to the court and say the parliament improperly did this? It's unconstitutional because I don't meet the grounds. Please declare court whether I should properly be removed or not. Because I don't see any bar to doing that. And I think that puts us in a very difficult situation.
Let me invite, I have some thoughts on the matter, but let me throw the conversation open to others. Ms. Wilkins from the technical team, or Madam CPC?
Miss Wilkins is
Yes.
not in attendance.
Any other member of the team? I was trying to. So, all right, I don't know who's shy, maybe it requires further consideration. I thought, Senator Golding, that you were leading to having raised those questions, we're going to, similar to what Member Charles asked about whether if the ground has been determined to be made out, then the real dilemma is how should the Parliament respond to that? How should the Parliament respond to that? Whether you can have a quasi-judicial body saying that these grounds have been made out, and then the Parliament saying we're not accepting it.
But they
What
can.
should that no, that's what I'm saying, is whether the scheme should be a different one for after, if the purpose of the quasi-judicial body is to consider whether the ground has been made out and to make a recommendation, how should the recommendation be dealt with?
That's part of my concern.
Right.
And what I'm saying is that if what this quasi-judicial body does and can only do based on what is proposed is make recommendations. And I've in recent times experienced how bodies make recommendations. I am not bound as a parliamentarian to agree with the recommendation. I can vote contrary to the recommendation. But I cannot disturb a judicial decision other than by way of the highest judicial decision.
So the matter has to honor important principles of natural justice, but it is not a trial. It's not a crime that you're saying. And our jurisdiction does have a model where grounds are established and objective criteria are set. That is why the consideration of the matter is being put in the hands of trained and experienced people, not lay people who do not understand the principles of law. So that there is nothing improper or odd or revolutionary about saying that prescribing grounds and allowing for a process to determine whether the ground prescribed has been made out. Not a simple allegation, because people can allege anything. I think because we are we have so many examples in the jurisdiction where people equate an allegation with guilt. In other words, or believe that once a matter is being investigated, the outcome is predetermined. I think those are part of the challenge, and we see that issue playing out in areas dealing with the Integrity Commission, another scheme, where it's almost it could be described as a certain level of perversion of our not understanding that an allegation does not mean that you are guilty. It could be a strong indication, but you don't come to a finding without a formality. I've said, and this is just my analogy of reason, I remember when there was this 8 murder somewhere in Clarendon, Cherry Tree Lane, and the discussion and the conversation was brewing in the public space. A suspect was taken in. I think they got a confession out of one of them, or the evidence was so compelling that the question was not whether the suspect taken in, who was eventually convicted by way of guilty pleas, if my recollection is correct, did the act, but it was that you could not convict him without going through a process. And that is where due process comes in. So a presumption of innocence, and again, just by analogy of reason, does not mean that a suspect taken in or even formally accused did not do the act complained of, the crime. It just means that you cannot formally convict him, meaning return a verdict of guilty without going through a process. And that process involves specifying a charge, allowing a plea to be taken. If there is a plea of guilty, the law says that the prosecution is relieved of proving anything, but the court still has a duty to ensure that it is a properly entered plea. If it's a plea of not guilty, then you have to try it, and the person bears no burden of proof, because the burden of proof is on the Crown, and it's proved to a standard beyond reasonable doubt. And then you know that even a person who has done an act can be acquitted by virtue of technicalities. I use that analogy all the time to say we have to be careful in how we conflate issues, not saying that you are conflating, so that prescribing grounds and saying that the grounds have to be made out is setting out a process. This is not conviction, no. But you hold the high office because you are considered eminently qualified to hold the office and to discharge the functions of office. And if a time comes when you are no longer so viewed, you go through a process. It can be the holder resigning. That's why you have removal. You can remove yourself from the office voluntarily, or a process may be used to remove you in certain circumstances. So we have to go through a process ourselves of ensuring that we are not conflating the issues and that we provide properly for the scheme. Well, but what I see arising that leaves me with more thought than less is what would be the implication of a recommendation being rejected by the Parliament. And I think that is where your question meets some of the concerns raised by Member Charles, and it's something that we will have to consider further.
And that is the more we discuss this, then I have to add further concern and question. I apologize. Because I do not think it is true to say that the grounds set out in the proposed bill are not dealing with criminal matters, because they are drafted in such a broad way that they do capture criminal matters. And I draw your attention to paragraph C. If the president behaves or is behaving in a manner that brings the office of the president into disrepute, could very well capture sexual assault.
Yes, but the Parliament would not be charging the person for sexual assault and convicting him. That would be a court matter.
It would be.
So that matter would have to be referred to the court.
Yeah, but let me finish my thought. Because if a president were accused of sexual assault and the Parliament then was triggered to engage the removal provisions, can it do so before there's a determination of guilt for the sexual assault? What we would have is a situation where there's a criminal matter in the courts, potentially, the Parliament engaging a process to deliberate over whether the behavior leading to the charge or causing the charge was one which brought the president within this ground. And if you had a situation where the Parliament engaged this process and declared, accepting the recommendations of the panel, let me not get it too complicated, that the president should be removed, but thereafter the very president is acquitted in the court, what are we, where are we? Where are we? A court says you're not, but the Parliament says your behavior is such that you should be removed. And it may very well be that there is behavior leading up that the Parliament can cite. But if the behavior is what the court has said no, does not render him guilty, then I'm concerned. I do not, as I am in this moment, and it requires a little bit more research and thought, I am concerned about enshrining these grounds in the Constitution.
So I would say that we run ourselves into difficulty if we try to preempt and try cases or circumstances that would arise. When you set a framework, you set a framework that should be workable, that meet objective criteria. I am in the maybe in the minority, which says that the determination of impropriety should not rest entirely on a criminal conviction. Unfortunately, in this jurisdiction, and I think it was based on the pronouncements of a former prime minister, no less, who elevated the standard of fitness and propriety to hold public office on whether misconduct rises to a criminal level. Just to say for myself, I don't share that view. I think that there is a lot of misconduct which falls short of the criminal standard, which in a different kind of society should render some persons from holding office for the time being. Having said that, I'm not one who believes you cast out people for a day. I think our society has operated in extreme. It's either we can do no good or we can do no wrong, and we polarize. So if allegations of misconduct involve an allegation of a crime, then it would be expected that that matter would be reported and the normal criminal investigation takes its course. But to say that if matters may touch and concern a crime, then unless and until that aspect of it is determined, nothing should be done. I don't, that's not where my mind is on the matter. I do understand and appreciate that in investigating allegations of misconduct, great care has to be taken in ensuring that appropriate natural justice takes its course. And if a crime is alleged, then the Parliament is not a court of law. In our constitutional system, a crime is a conviction is done by the court. So again, it will all depend on what throws up in a proper case. But to say that something is faulty with a constitutional framework which sets out grounds on which someone may be removed from office, I don't know that I share that view. But we can't answer all of the questions. No, they would have to be thought about.
I have, you know, when you reframe what I'm saying, I get a little concerned because
may I suggest that you frame it so that we can frame it so I don't have to reframe it. Please just frame it so we can record it as such.
I think I've been doing that all along.
May I just ask you to repeat it for clarity?
What you said a while ago about the Parliament not doing anything where there's a criminal, or the Parliament allowing a criminal matter to proceed without doing anything, because the criminal matter properly belongs in the court. There's nothing in this bill that stops the Parliament from beginning the removal process, notwithstanding that the circumstances surround a criminal charge.
I think no, Senator Golding. The process commences with a motion, right, which alleges conduct that would fall within one of the grounds.
And I'm suggesting
that's where hold on, and that is debated
within the grounds.
So that all of that could be debated in a motion which says based on what is alleged, and that is why a threshold is set for a vote to be taken. The matter is aired so that if it is alleged that the misconduct involves that, the matter coming into the parliamentary realm, it is quite open in the decision to say in the debate and ultimately reflected in a vote of a threshold, of the threshold that is set at the level that it is set, that these are matters that would be more appropriately dealt with in a criminal proceedings. And then depending on what has happened in the criminal proceedings, then we should. But God forbid that I would.
But Madam Chair,
Yes.
really, we're talking about a situation where you have a potential criminal matter, and you're saying to me that there is nothing untoward about a motion being tabled that is going to cause debate to ensue on a matter that is criminal and is within the courts.
I did not say that.
You just said that all of these things would be discussed in a debate, and you have a vote that rises.
Hold on, member. You ask about whether there is a process that would initiate it. That's what I was answering, and I went on to other things.
I am saying there is a process that initiates it. I am saying that nothing stops the Parliament from initiating the process, even when there is a criminal charge. The Parliament, so the motion that you're talking about can still be laid and can still be debated on the grounds of these 4 grounds that the person has misbehaved. And I'm saying that that would not be appropriate, because you then have the Parliament seek to remove and having a debate about removal when the circumstances are circumstances that are involved in a court process. So by the very fact of that, by the very fact that the matter would be sub judice, the Parliament could not begin that. The Parliament ought not to begin that. And you're saying that, and I'm saying no, they shouldn't.
You know, Senator Golden, your questions raise so many issues. So the principle of the sub judice principle appears in the standing orders of the House. They appear in the standing orders. And I have seen where even when attempts are made to discuss matters and a point of order is raised on that standing order, more often than not, that has been honored. So we do have rules in relation to those matters.
Not in the Senate, not with Senator Brown.
Again, I think, you know, I've said to someone that this constitutional reform process has brought me so close to the concerns raised by the people, and I'm hearing them echoed in what you are saying here. Right now, we have a provision in these regulations, the public service regulation, and I think particularly the regulations that relate to the police, where you can't take action against either a police officer or a civil servant, where like misconduct also allege criminal conduct, and you have to wait for the court process. And what I hear, and I heard it a lot when I was in the role of Attorney General, I hear superior officers in government ministries, departments, and agencies bemoaning how their hands are tied with people who are not doing their jobs, how the process is so long and the court process is so drawn out, and they can't take action, and important positions are occupied by people who are just dragging out things. And you know, we have a reckoning sooner than later. Like I say, because there is such knowledge gap in the society in so many different places, and I know I have to be careful because people can take offense to this being said when no offense is meant, that public administration has just gone awry. The rules that guide, the well-established rules that guide, either people are ignorant of them or they totally disregard them in the public administration of Jamaica. And that's why there's so many concerns raised about issues of accountability. Because in essence, what we have come to say is that no matter what the wrongdoing is, if it don't meet the level of a crime and a conviction, nothing should be done to the person. And then we have people who are reluctant to even activate a process and document a process. Or the lines are so blurred about what is proper and improper. So it's not intended that you are to activate the removal process as your first point of discussion. In constitution making, a host of matters are left to constitution convention. Not everything is written in the document. But we also see a trend, perhaps because what the researchers say, because of, again, the knowledge gap, because that's what the research point. More and more details are coming in constitutions. So we have to grapple with all of that as we try to remake the Constitution. And it is for this reason why we say, if we were to do everything all at once, even though we know what the outcome, we would never get it done. So we have to leave place for proper consideration of issues. And when those issues are not properly considered, that's why we have recourse to other avenues to correct the impropriety or the irregularity. But, you know, I am hearing so many things that are provoking thoughts beneath the surface and perhaps reflect and mirror concerns raised in other places. Who are the people administering our systems? Are they people who lack training, experience of life to know when to do things? So are you building your system review processes? But to say that should the elected representatives determine that after going through a process and providing an avenue for someone to be heard, that somebody is entitled to a position. Because I'm just thinking of a worst case scenario, go through a process and someone say, I am not giving it up. I don't get to the vote. The vote the threshold wasn't met in the parliament. And the entire office is under cloud. And somebody then say, I am not moving. How then do we even have the dignity in the office? These are things that as a society, these are cultural matters. These are not things that we can legislate around. But these are things that we will have to deal with. And we see that coming up in other examples. Conduct so egregious that people say, should such a person continue to hold office? Should such a person continue to be given a nod to hold office? Should such a person of themselves consider it no longer proper to hold the office because there is no public confidence in the office? It's a whole host of cultural issues that we'll have to come to terms with as we further the goals of an independent Jamaica. I'm saying all of that to answer all of the questions. I can only tell you what policy considerations inform the provisions of the bill. And if further considerations need to apply, then we go back to the drawing table. But we are not going to be able to predict every possible scenario. And that's why the power to make law and respond with agility exists. Because sometimes you only go to the frontier that you know, and the matters push the frontier forward. But again, people are skeptical because the wheels turn so slowly. And even sometimes when the courts make a judgment, which the appropriate response should be a legislative one, by making a change and adjustment to the legislation, there is slowness in it. That's why Prime Minister Holness has said, there are so many things that as a nation we have to respond to. He has carved out in his own arrangement of government a special place that is going to have targeted and focused attention to these matters. And the hope is that there will be agility. First of all, you're making people competent. They can pick up the framework where we provide their views and portal with a interaction in it. It doesn't work as before us. Once we become enlightened and our eyes, we want everything to be. We can't do it all at once. We're going to take and we're going to go forward and we're going to progress. So some issues have been raised. It will require us to do some further deliberation. And then we have submissions from members of the public on the provisions that we will answer. I believe this is as far as we can go today because we have some other matters on the agenda, also on the legislative agenda that requires our presence. So we're only at on this. I would just say that going forward, I'm going to ask them try to just discuss in a way provisions, come back. And this is not shutting down any that may arise after further reflection, but as it is possible, then we are going to have to try as far as is possible to be present and have discussions on the matter, and then we back on reflection on them, because time is limited, and we want to make progress on this matter. Let's see. Just give me a moment, please. All right. Okay, so on the bill, by PC, based on the discussion, we have to consider whether, let me just go back to the clause. Clause in respect of the panel. So we'll have to spend some time looking back on the framework from the panel is created. Some issues to consider specifically is who should be to indicate the removal of the president. Specifically, should it be limited to the leader of government business, or should it be open to any member of the parliament? and whether the panel, the quasi-judicial panel, should be named after consultation between government and opposition, so just to say that conventionally, this is what should happen, but the question is whether it should be expressly provided for, whether the size of the panel should be expanded, given the provision for it to continue, even if there is a defect in number. Whether the vote to remove should be by absolute majority, similarly to the vote to confirm. And I think we should do the converse, or whether the vote to confirm should be by 2/3 majority, to the vote to remove, and then we would consider.
Repeat the second, please. The first.
No, I'm saying that if we are to reconsider whether the vote to remove the president should be by an absolute majority as opposed to a 2/3 majority, then we should also, by extension, consider or reconsider whether ex ante the vote to confirm should be by a 2/3 majority instead of an absolute majority. And if the same principle apply, that you're not, then we would just have to consider it along a certain line. All right? The other matter is whether the interim report required to be submitted on an application for extension of time should be limited to advising of the progress made so far and reason for the extension, the request, justifying the request, and the reasons justifying the request for further time. Let's see. 5. Just what should the power of the Parliament be, where there is a recommendation that a group specified has been made out. So we need to look back on the power of the Parliament in respect of the recommendations of the panel. So the question of reconsidering the power of the Parliament vis-a-vis the recommendations of the investigatory panel has to do with any discretion to reject a recommendation. And that is regardless of what the recommendation says. And I think to close the gap, we have to consider as a sub-issue of this power of the Parliament vis-a-vis the recommendations of the investigatory panel is what would happen to a president where a recommendation is made that a ground for removal has been made out and a Parliament votes otherwise. So all of these are, this is another issue that is tied up in a reconsideration of the power of the Parliament to deal with a recommendation of the panel.
Sure, by
So what would happen
of that question, the question I raised, which is, what is there finality to the parliamentary vote? In other words, is it challengeable?
We look at it. Yes. 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 The intention is for the Parliament to be final on this matter, but that's the intention. Yes.
Which then comes back to my concern about interpretation of the Constitution.
Like I say, I frame it a little different. I think that while I understand your point, it's not so much a matter of interpretation in the strict sense of a judicial branch of the judicial branch interpreting whether the Constitution, what it says or not. But we can't go back into that at this time because we'll consider and come back. And this is a matter that really we have to do some reconciliation. I put on another hat. If the Constitution sets out a ground and it sets out a process for determining that ground, and that ground has been satisfied, then once it is satisfied, then you really can't, what should follow automatically is a removal from office. But we will have to reconsider how we have provided for this matter. All right, anything else that should be considered? Oh, the other is, so number 6 is whether the residency requirement for a presidential nominee should be permanent residence as opposed to ordinarily resident. Bearing in mind that temporary absence from the island does not mean that you are not permanently resident. So it's a residency requirement for the nominee. Residency criterion. All right, so we would treat the considerations of these questions as a continuation of the review of the bill, even though they arose out of matters arising. Madam Committee Clerk, may I ask you to thank you for the printed copy of the matrix. May I ask that those who require printed copy, that they be provided with, otherwise, whatever updating needs to take place. And may I ask members of the committee between now and the next meeting to spend some time going through the matrix to allow for greater efficiency in our consideration when we get there. Our next set of provisions that we will go through will be the Senate provision. The Parliament, picking up at clause 15, 16, 17, 18, 19, 20. All right, so for next meeting, we will go through the provisions dealing with the Parliament. And then the meeting. So I'm inviting members of the committee in preparation for our next meeting to please review or read through the provisions dealing with the Parliament. After that, we will spend some time going through the proposal to reform the alteration mechanism, and then we will come back to the any revision of the framework as against submissions made and questions raised. So that's other business. Any member has any other business? Anything that I may have missed, the members of the ministry team, technical team? The date and time of our next meeting would be next Wednesday. I'm going to ask that it be set for 11 instead of 10 to allow me to deal with another matter ahead of the start. All right. So next Wednesday is what, the 18th?
Madam Chair?
Yes.
Excuse me, please. I'm seeing where there is a tentatively scheduled meeting of the Joint Select Committee on the Domestic Violence Act, 410.
Yeah. 410. So, and that would be for the entire day?
I would not be able to say at this point how long the meeting would last. The committee has not met in quite some time.
All right. May I suggest that we still put our meeting there subject to confirmation?
Will do.
And then we can see. All right?
Yes.
For 11.
Yes.
Either 11 or 2. All right? Let me thank members for your robust participation. I hope that the students present in the gallery would have been enriched by the discussion. If they are still there, may I invite members members and support team in the chamber to please interact with them.
They have left, madam.
They have left. It's 1 p.m. If someone move for the adjournment of the meeting.
Wayne Smith.
Thank you.
Second.
Seconded.
Thank you. Meeting adjourned.